My name is Tim Hayes, and I'm the Executive Director of AIR CRE. The topics Jim and John will be covering over the next 60 minutes include the spike in tenant and owner disputes in 2020-2021 due to COVID-19 business shutdowns, the massive backlog in the courts, what is mediation, what are the benefits of mediation, and the types of cases to mediate, and then the AIR CRE mediation service. Now let me introduce today's presenters. First, Jim Sullivan. Jim has been a successful commercial real estate broker for almost 35 years with a focus on South Bay industrial market. He has been a member of AIR CRE's board of directors for 22 years and was the president in 1998. For the past 13 years, Jim has chaired AIR CRE's Dispute Resolution Committee, where he has mediated numerous disputes involving complex issues with millions of dollars at stake. Jim graduated from UCSB with a degree in history, and in 2018 earned his master's degree in dispute resolution from the USC Gould School of Law. John Paglisotti has 35 years of experience in the commercial real estate industry as a broker, owner, institutional asset manager, educator, and author, and for the past decade has provided education and training to thousands of real estate professionals. John is a respected mediator who brings a high degree of understanding and meaningful solutions to every matter and has mediated disputes in Los Angeles and Orange County courts, as well as with the California Association of Realtors. John received his bachelor's degree in political science from UCLA and a certificate in alternative dispute resolution from Pepperdine's Strauss Institute. It's my pleasure to introduce Jim Sullivan and John Paglisotti. Take it away, man.
Thanks, Tim. I appreciate that, and welcome everyone. I'm pleased everyone's attending today. So right now, there's kind of this perfect storm brewing. Actually, it's here when it comes to commercial real estate disputes, and there's two fronts to this storm. And the first front of the storm is the eviction moratoriums and rent deferral programs that I'm sure everybody's aware of. Now, this is not a legal seminar on those programs, but you need to be aware of them for this portion of the presentation. And generically, you can find out about them if you Google search AB 3088 and SB 91. That's what the state of California, that was their solution to rent deferral and eviction moratoriums. However, as many of you know, many of the different municipalities throughout California, the counties and cities, took that and ran with it. Those two laws were kind of the tip of the iceberg. And in fact, every city has kind of come up with their own ad hoc version. So I would urge you, if you're attempting to take advantage of either of the eviction moratoriums or the rent deferral programs, understand particularly to your city or municipality or county what the law says. Most of those programs for commercial real estate either have expired or are expiring in the next month or so. Now, residential is a different story. They're giving a little more latitude to the residential tenants. All of that said, these various programs, moratoriums and deferral programs, were ad hoc in nature. So, and this is not a criticism to the governments and the municipalities and the governmental agencies that put these laws into place, but they were faced with a pretty immediate emergency. We need to shut down the state, and then we have to respond with these ad hoc laws. The point is, these laws are not comprehensive, and they really didn't take into consideration the complexity of commercial tenancies and the implication these laws would have on the leases themselves. So for example, most of these laws say the tenant doesn't have to pay rent for X period of time and has to pay the rent back at another period of time and is given 12 months, say, to do it. And the laws also said, and during that period, landlords, you can't evict these tenants for not paying rent. But some questions, it begs certain questions. For example, what about the triple net costs? While tenants didn't have to pay rent, did they have to pay those costs? Now I can hear all the attorneys in the audience saying, well, rent is often, or these costs are often considered rent, and so on and so forth. But it wasn't made abundantly clear. How about CAM charges? And it gets a little bit more murky when you start thinking about other obligations under the tenant's lease that have monetary implications, but are not necessarily a monetary responsibility to the landlord. For example, maintenance obligations, that costs the tenant money, but that's not a direct payment to the landlord as rent. Well, it's a money expense to the tenant. Is that part of this rent deferral? Would that be considered part of the rent deferral? The insurance requirements that the tenant has under the lease, what about that? How about the repayment of tenant improvement dollars? If the landlord and tenant have an agreement that the TI dollars are paid, maybe separate from rent, maybe on a different schedule for rent, is the tenant still liable for paying those? And that TI dollar concept kind of goes both ways, because as we all know, landlords are giving TI dollars to tenants. So I'm a landlord, I put a new tenant in the space, they stop paying rent and they hand me their bill for the TIs that they did. Am I obligated to do that? Is that fair for me to have to start handing a check to a tenant to reimburse TI dollars when I'm not collecting rent? What about holdover tenancies? So a lease expires, a tenant can't move out. They can't get a mover to the property. They can't get their employees to the property. They can't effectuate a move. So now they're in holdover, or are they in holdover? Are they subject to the holdover provisions of the lease, higher rent? Some tenants would say, well, I'm going to go on a month to month, and I do that by paying a rent for that month to the landlord. Now I've created a month to month tenancy. But if I don't have to pay rent, can I effectuate a month to month lease without paying that 1 month rent? From the landlord's perspective, return of security deposit. So I have a tenant that moves out that wasn't paying rent for 6 months. Their lease expires, they move out. Do I have to return the security deposit, or can I wait until they're paying me their rent back until I return the security deposit? And there's these delay in possession potential problems. Landlords may not have been able to prepare space for tenants properly. They couldn't get their contractors to the building. They couldn't get the utilities taken care of, and so on and so forth. Building services in office buildings. What if the landlord's janitorial staff wasn't showing up, and their building engineer wasn't showing up, and their day porter wasn't showing up? I mean, does the tenant have a complaint against the landlord? And this brings up certain concepts, for example, of default. Did these modifications, or did these laws, these ad hoc laws that the government brought, did they modify the lease? Has the lease now been modified so that the tenant's not in default because they didn't pay rent on time and they're paying it on a deferred basis? Was that addressed by these laws? That there's the tenant reduction of income. It was kind of the benchmark for the tenant not paying rent. So the tenants, if they had reduced income or revenue, that was a validation for them not to pay rent to the landlords. Well, does the landlord have audit rights? Can the landlord request tax returns? Can they request financials? Can they request audited financials? What about tenants that entered leases, what I call with their eyes wide open? In other words, tenants that entered leases, let's say in August of last year, when they understood there was shutdowns and they understood potentially what the economic impact was on their business, are they still protected? That's just leases. Think about the escrows. Think about escrows that didn't close after contingencies were waived, hard money was passed through, and all of a sudden there's a lockdown and buyers are having issues with lenders or having issues with other elements of capital raise on purchasing a property. What about material change to the property? So now you have an escrow and the contingencies were waived, and suddenly there's this new law where 100 tenants in your shopping center or in the seller's shopping center don't have to pay rent for a year. Is that a material change to the deal? Does that give the ability for the buyer to back out even though they've passed through their funds to the seller? And I've heard all sorts of notions on how these disputes are going to be dealt with. Brian Mashian, you may have attended a AIR CRE town hall a few weeks ago that Brian Mashian, a great one, and Brian's a great attorney, and he talked about this notion of maybe force majeure being brought into play. Well, he had to look all the way back to World War II for case law on the government shutting down businesses. And there's these notions of impracticality and impossibility of use. All these things are being tossed around. I can tell you, I'm not an attorney. I spend a lot of time with attorneys. I do a lot of expert witness work. And the common theme is this is uncharted territory. There is no absolute answer to this question on how this will be handled. And this town hall isn't about giving answers to those problems. The point of the town hall is to talk about the spike between tenants and landlords and buyers and sellers in disputes that have candidly already started and will continue through 2021 and beyond. So there's going to be a lot of disputes revolving around these pandemic orders, the shutdowns, the rent deferral programs, and the stays on evictions. So that's one front of the perfect storm. The next front of the perfect storm is the massive backlog in the courts currently. So pre-COVID, if I got a call from an attorney that wanted to retain me as an expert on a case, I would always ask, what's your trial date? And they would say August 1st. And I knew right away August 1st meant sometime in December if we were lucky. Because of the court calendars were so backlogged already, I have yet to see a trial date take off on time. And generally, the second time, it wasn't surprising to get delayed another time. So an August 1st trial date could quite literally turn into a March 1st trial date. So now imagine this. You take that backlog calendar and now you shut the court system down. Because of COVID, the courts shut down and they're just coming back online. So it only served to exacerbate the problem. So as an example, Orange County held 150 civil and criminal trials in the 10 months from March through December last year. This is according to a court spokesman. The court typically has more than 900 trials over that approximate same period of time. So there's been an 85% reduction in the trials in Orange County that were heard. I went to another webinar and the attorney said that in Orange, and this was in September of last year, and the attorney said that there were 25,000 backlog cases in Orange County alone. Now let's talk about statewide. In criminal and civil cases spreading throughout California's court system, half as many cases were resolved. 1.4 million fewer cases were resolved from March through August last year compared to that same time period in 2019. I had to read that twice when I read the article. 1.4 million over that short period of time. And that's information coming from the court itself. My understanding is the way the court is as the courts reopen, the way they're prioritizing cases is criminal cases take priority, family law is next, and civil law is coming in third. I went to another webinar and a recently retired LA Superior Court judge said that civil court judges were being prepped to hear criminal cases. So the bottom line is this. I just was in a deposition day before yesterday, and I talked with the attorney about it. He said, I'll feel lucky if I file a case today. I'll feel lucky if I see the inside of a courtroom in 3 to 4 years. So suffice it to say, potential court dates, when you're a disputant and you're thinking about filing a lawsuit, you may not be seeing the inside of a courtroom for years. The time to go to court is not being measured in months anymore. It's being measured in years. But fortunately, there is a wonderful solution to this dispute resolution that is time tested, is extraordinarily successful, and we'll talk a little bit more about why I think it's the way to go. But before I do that, I'll ask Jim to talk about a little bit about what mediation is.
Thanks, John, and thanks to Tim for the nice introduction. You've heard the litigation horror story from John, and the courts weren't closing the backlog before COVID. I don't know that they'll ever be able to close the backlog now. John and I believe, as do many courts, judges, and others in the field of dispute resolution, that an important new way to deal with this, not new, but an important way to deal with this is using mediation. Mediation is a process And many people have probably heard the term. Many people may even confuse it with arbitration. But what makes mediation unique is that the parties have control over the outcome. There is not an arbitrator rendering a decision. No judge is rendering a decision in a bench trial, nor is a jury rendering a decision in a jury trial. It's up to the parties, along with their attorneys, to figure out the best solution for the problem they have. There are many, many benefits to this. One of which is that if the parties have an ongoing business relationship, landlord-tenant, broker-principal, it's often a fantastic way to salvage a relationship. Mediation brings the temperature down significantly. Litigation is a challenging environment under the best of circumstances. Attorneys are trained litigators are trained to be zealous advocates for their clients. And if you are in litigation, that's what you want from your attorney. However, that tends to make the process more confrontational and not necessarily good for continuing a relationship. Mediation is a more relaxed process. It is less formal. It is not bound by the same procedural constraints that arbitration or litigation or any court proceeding is bound by. And it's an important alternative for the parties to consider. Now, we've talked about more relaxed, no judges, no juries. To be clear, the parties in mediation are, especially in a commercial mediation, are often represented by attorneys. And that's largely because when the dispute first erupts, most people, first or second thing they do, pick up the phone, call their lawyer, talk to the lawyer, find out how strong their case is. So by the time there's been some conversation, both parties have probably hired an attorney. This is a good thing. Everybody should have legal advice and counsel. Mediation is completely open to that. John and I, John has mentioned working with attorneys, as have I. The more the merrier is one way to put it. I'd say another big value to mediation is that everybody who is part of the dispute has the opportunity to be heard. Both sides get to express themselves, tell their story, explain why they're upset, why they think they've been wronged, why they think they did nothing wrong. And believe it or not, sometimes that's all it takes. It may seem odd, but even in a commercial dispute, having somebody listen to your side of the story can help break an impasse. You can help the parties reach a settlement. When you're in an arbitration or in a courtroom, the people who tend to speak the least are the two parties involved. It's the attorneys, it's the judges or the judge. That's a valuable aspect. Mediation tends to cost less because mediation most often occurs before the discovery phase of litigation. Most attorneys will tell you that, first of all, litigation is expensive no matter what, but as it proceeds down the timeline, it gets more and more expensive. It should take less time. And to John's point, you don't need a court date to mediate. All you need are the parties, their lawyers, and the mediator. You've only got 5 parties that need to schedule it. They can schedule it at any time. You don't need a courtroom to do it. In the old days, we used to need a conference room or 2. Nowadays, virtually all mediations are done via Zoom, quite successfully, by the way. So that increases the opportunities for having a mediation, people don't have to travel. That saves money. There is less formal preparation. A mediator will expect each side to prepare a brief explanation, no more than 10 pages, explaining their side of the story, and they'll get started. A mediation, even a complex mediation, can be resolved in a one full long day. And I can't emphasize enough the importance of the fact that the parties are in control. If one party or the other objects to anything about the direction the settlement discussions are going, that could be the end of the mediation. But it's important for the parties to know that nobody's going to force them into a decision they don't like. And at the very end of the day, and John and I have talked about this, it may sound flip, but it's not. Parties who mediate have nothing to lose. In almost every situation, if the mediation is unsuccessful, they can move to a more formal binding arbitration, or they can go straight to the courtroom. And one last key point is that everything that happens in a mediation is confidential. All of the communications among all of the parties cannot be shared for the purposes of the arbitration or the litigation. It's a closed system. Everybody's in a cone of silence. So parties are allowed or enabled to speak freely without concern that what they say will be used against them. I could go on and on about the benefits of mediation. I know I'm a biased party here, but given the circumstances, I think parties who want to put disputes behind them have to give very serious consideration to mediation as the way to accomplish that.
Yeah, Jim, I just tying into that. That was excellent. And I would just make a few additional comments.
Please.
Jim mentioned that mediation is less expensive. What he means, there's no discovery, there's no depositions, there's no filings, there's no motions being made, there's no court appearances. It's less time consuming, which means it's less emotionally taxing. Forgetting for the moment that the biggest difference, one of the biggest difference in mediation, it's not contentious. It's not a zero-sum game. Court and arbitration, zero-sum game. One winner, one loser. There's no winners or losers. That's not what's being sought in mediation. So, and it's not as intimidating. I mean, walking into a courtroom and the judge and all the woodwork and the jury and the attorneys and the court reporter, this is very, especially over the Zoom format, this is a lot less relaxed, or a lot more relaxing. You can sit literally in your extra bedroom that's now in an office or in your living room, wherever you're comfortable, and you can have a discussion. And I will tell you, my experience on mediation is this: no one has ever walked away from a mediation settlement and said, "What just happened?" A lot of people walk away from a bench decision, a jury decision, or an arbitrator's decision, gets out in the hallway and looks at their attorney and says, "What just happened?" One of the reasons I got into mediation is I do a lot of expert witnessing, and I saw in the courtroom that when the winner left the courtroom, they had their tail between their legs a little bit less than the loser. There's no smiles, there's no popping champagne, there's no high fives going on. And I thought there's got to be a better way to resolve disputes, and it's mediation. And as Jim mentioned, it may sound a little bit catchphrasy, but you really don't have anything to lose, because you give it a try, you do your best, it's successful, depending on the statistics are all over the place, but it's successful the majority of the time. And you just walked away saving a boatload of money, a boatload of time, not as frustrated, and potentially having an ongoing relationship with the other party, if that's the nature of the relationship.
So I think, are we ready to move to types of cases? John, why don't you, since you're on a roll, take a few of these and explain what mediation is good for, what kinds of cases.
Well, mediation is good for virtually any type of dispute. By the way, a case doesn't have to be filed. In other words, you don't have to be a litigant already. You don't have to have a case filed in court. You can mediate at any time, pre-filing, during the filing, 2 months into it, 2 years into it. You can choose to mediate any time to settle your dispute. Now, this town hall is obviously focused on real estate. So these are kind of the typical matters. I mean, I've already mediated a couple escrows that paralleled the fact pattern I offered before, where there's this money went hard. However, we've got this shutdown and now that's creating problems. So buyer and seller deposits is a common one. Disclosures. Did the buyer make or the seller make all the disclosures they were supposed to? Reps and warranties, waiver of contingencies, how they were waived, prompt closings. There's, Jim, you can talk a little bit maybe about the landlord-tenant disputes that could be mediated.
Well, we all know, John and I come from, well, I come from a brokerage background. John comes from a brokerage, asset management, and property management background. So in effect, we come from a real estate transactional background. We're used to dealing with buyers, sellers, landlords, tenants, and any combination thereof. Any of us who've been in the business for a while know that landlords and tenants can disagree. They sign the lease, put it in the desk drawer, and then something happens. And one side or the other is unhappy and believes the other side should be responsible. And that usually means the other side should pay to fix the problem. So it can be, pick one, the roof leaks. What does the lease say? Was there a warranty in place? How long did the warranty cover the roof? Was the tenant properly maintaining the roof during the warranty period? What does a rent adjustment mean? In the old days, we used to talk about a range between a 2% increase and a 5% increase in the CPI. Thankfully, we've kind of adjusted to say it's 3% per year, but we may end up going back to that range, calculating what that rent increase is. Does it cover net expenses? Does it not? And not every lease is written clearly. And this is where the disputes arise, unclear language. And I want to add one point that I think is very important when considering AIR, CRE to assist in mediating, is that with John and me, you're getting what we like to call subject matter experts. With all of the experience John and I have in the business, plus all of the years we have serving on the AIR CRE contracts committee, I doubt there's a paragraph in any of the AIR documents that John and I haven't discussed in a group of a half a dozen or more people, vetting every which way, considering every possible interpretation or misinterpretation. And we bring that kind of expertise to the disputes that are listed below. Not to brag, but John and I doubt there are many other people in this field who can make that same claim. How about broker disclosures, John? Broker v. broker principal.
Yeah, I do a lot of expert witnessing. All the brokers on this phone, on this town hall, need to know that that is one of my biggest calls I get from attorneys is their brokerage duties and disclosures brokers are supposed to make and didn't make or urged. And then I'm not talking just about agency disclosures. I mean the responsibility to disclose material facts, how to counsel or not counsel, what they're supposed to share or not share with their client, with the buyer, with the sellers. And that's a big deal. And I think that it's important to note that again, any of these matters can be mediated and can be mediated successfully. They're really no different than any other dispute. They can be mediated successfully, and as Jim mentioned, and maybe it's time to jump into the next slide where I'm going to share the screen. So the good news is, what we've offered so far is kind of this perfect storm for commercial real estate disputes that's occurring. And we've offered what we feel to be, and not just us, but most of the legal community feels to be a great alternative to arbitration and to actually going to court. An option that is, as we mentioned, less contentious, less expensive. The disputants are the ones in control of the process, and you walk away feeling a lot better about your decision because you didn't end up at the whim of some arbitrator or some judge. And absolutely no disrespect meant to any arbitrators or judges that may be on this town hall, but you're in control of it. So the good news is that we now, and when I say we, AIR CRE now has a wonderful option available to the, and I'm looking at my screen, I attempted a screen share, and I'm going to need to be given control of the screen. So AIR and CRE has a new service, mediation service, that we're going to offer. And when I say new, it's kind of new. And when I say kind of new, for the past 60 years, AIR, CRE, and I'm going to interrupt here and just a technical note. When I go to share my screen, I'm getting a window that says you cannot start screen share while the other participant is sharing. There we go. Okay, perfect. Thank you. No town hall is complete without at least one small technical difficulty. I appreciate your patience. So if you go to the AIR CRE's website, you'll now see that there is a new window available, and that window is the AIR CRE mediation. And there's several topics that we'll cover as we go through this screen. So you go to the home page, and if you tap on AIR CRE mediation, it will take you to that splash page, the AIR CRE mediation splash page. So I want to talk a little bit about what the service we have to offer is. As I mentioned, AIR CRE has been doing mediation for its members for over 60 years. Jim's been doing it for years. So for its broker members with broker disputes, AIR CRE has been offering that service. So as we look at the splash page, it's a great page, and we can see that there are several different icons that can be chosen, and it's very self-explanatory. So as we scroll down, and on this web page, you can either hover over one of the icons and go to that particular topic, or as you can see, you can actually go down and take a look at each icon represented on the page itself here on the splash page. So the services that we're offering, and Jim kind of dialed into this earlier. So AIR CRE has been, for 60 years, been a name in commercial real estate for obvious reasons. And we publish the forms, and we're a brokerage organization and an association, and we offer services to the brokers. So now the service we're going to offer is mediation. And the mediation service, one of the things that sets AIR CRE apart from other mediation services that you might find at AAA or JAMS or what have you, is we're subject matter experts. So what difference does that make? And I'll give you a couple examples of what difference it makes. When I get called as an expert and it's an AIR, particularly an AIR document, it's not uncommon for me to sit down with a very educated real estate attorney, very smart attorney, and say, you know, on this certain provision that's being disputed, you haven't considered this, because we on the AIR Forms Committee who developed this language, this is kind of what our intent was. So we have a particular expertise on the AIR CRE contracts. Beyond that, we have subject matter expertise. Jim's been a broker for over 30 years. I've been a broker asset manager, et cetera, for over 30 years. So our ability to come to a mediation and bring to the mediation that expertise leads to solutions, because we can sit down with disputants and say, I get it. When Jim and I get off this town hall, we're going to go back to mediating and practicing real estate. So we can say to the disputants, I get it. I feel your pain. I've been there. Here's a solution I've tried. Here's something you may want to consider. Have you thought about these particular facts about this case? And so it's solutions based. Now, there's great mediators out there that are attorneys and judges, absolutely fantastic mediators. But with our process, you don't even have to go through the process. The disputants don't have to go through the process of educating us. Say, see, this is how real estate works. This is how a rental increase works. This is how an options exercise. This is what happens after contingencies are waived, typically in the business. So we bring that as part of the services that we're offering. And again, here's some of the sample of some of the topics that we can address. And believe me, this is not an all-inclusive list. If we wanted to, we could have done pages of potential topics. But here are some of the typical topics that come up. The real day-to-day stuff, the charging of CAM charges, on purchase and sale agreement deposits, property information sheets, on owner agency relationships, there's dual agencies, there's commission payments, and so on and so forth. So I've talked about why use AR or CRE for mediation, and that's what I opened with. But you can see here a list of the reasons why you may want to consider a subject matter mediator to mediate your dispute. Now, that being said, while Jim and I are subject matter experts, we've also been trained, as Tim mentioned. Jim recently received his master's from USC in ADR. I'm in the process of getting my master's at Pepperdine. I've already got my certificate in it. And we both have actively mediated cases. So the process is going to be relatively simple. It's all done online. When we go through the mediation process, and you can see as you go through this page, not only can you highlight one of the icons that we first looked at, but any one of these text boxes here is also a way to get to the page being talked about. So the mediation process, for example, if we go to that page, as my 1998 computer struggles to get through the internet, the process is pretty streamlined. And it's very simple. And we have an FAQ icon on the main page that you can go to if you have any questions. And obviously you can contact AIR-CRE directly and talk to a live person if you have any questions. But the process is pretty simple. You request the mediation. You can do that online. When you request the mediation, AIR immediately receives that document, and then we contact the respondent. And now we're off and running. Then the next part of the process is either the parties can agree on a mediator, or if you want to, AIR-CRE can assign a mediator to the case. Next, is the mediation planning. Once a mediator is selected, the mediator contacts the parties and talks to them, kind of talks them through the process, tells them what their needs are. I need to see a short brief on the case. Maybe I need to see a couple documents. Keep in mind, this is not an evidence-driven process. The fact pattern is important, but the mediators are not providing a decision. In fact, our job is to stay neutral. Our job is not to take sides. Our job is not to say, here's the decision that I would give if you wanted me to. Our job is to try to facilitate an agreement using our training and our expertise. So there's not a lot of, give me a bunch of filings, give me all the documents, give me pictures, give me this and that. We may request, but we're not evidence driven. So once all that happens, the pre-mediation process, then we get into the mediation. Now, mediation shouldn't last terribly long. It can happen very quickly. And when I say quickly, I'm using the benchmark for quickly. I'm using 4 years before you see the inside of a courtroom. And all joking aside, it can happen relatively quickly. You can schedule it quickly. And usually within a couple of days, you understand if you're going to have a settlement or not. And as I said, the majority of the time you reach a settlement. So then once the mediation is complete, the parties finalize an agreement and they sign it. Those agreements can be submitted into the court as binding upon the parties, and you're done. And you've walked away from the process. The disputants have walked away from the process, generally feeling much better than they would have if they would have gone through the court process. And then, of course, there's a post-mediation follow-up. Now, as I mentioned before, and I'm going to go back to the mediation page. As I mentioned before, AAR-CRE has been mediating disputes for 60 years amongst the members. What's new to this process for AAR-CRE is we're now opening it up to the real estate community at large. So members still have this as part of the service. If there's a member-to-member dispute, there's still a part of the service that's being offered by AAR-CRE. Nothing has changed in that regard. And I'll talk in a moment about how members can go about continuing to take advantage of the service. There's a significant cost savings compared to litigation. Our services are, AAR-CRE's mediation services are competitively priced with everybody else. As I mentioned, the process is completely streamlined. It's all can be done online. All our documents are e-documents. Everything can be signed online. Everything can be quote unquote filed online. Responses can be made online. And as Jim mentioned, we can do mediation now. They call it ODR, online dispute resolution. I just did a mediation about a month ago. One of the parties was in St. Louis. They didn't have to get on a plane and fly and make a court appearance because the dispute involved a property in California. They didn't have to fly back for a deposition. They literally sat in their living room, and that's where the mediation took place. Now, that being said, when things are safe and we figure everything's safe to meet in person, we will also offer in-person mediation as well. So we're offering both those. If anyone wants to start a mediation now, they can literally go to the website and begin the process of mediating. So if for members, and just to, I mentioned, I'll show the difference, just so members know, because I assume there's a lot of members that are here. If you go to the FAQ and rules, and the rules of mediation are discussed in the FAQ, you can see there's a contact here. And part of that contact suggests that the members can contact AAR-CRE mediation directly and go through that process. It's a little bit of a different process. Some of the filing and paperwork is the same, but it's a little bit of a different process. But I want to make sure members understand that that service is still available to them. And all of that can be found very simply on the FAQ and rules page. And also, if you go to the Contact Us page, which Contact Us is also, that rule is also, or I'm sorry, that, come on, Dinosaur John, who still uses a flip phone. What's this bar up here? Members can go to Contact Us and they can find the best way. If you go down here and you put your inquiry in, there's a drop-down menu on the disputes there. And you can see there's a member dispute resolution as well as just a regular non-member AAR-CRE mediation tab, and that'll lead you on the way. But either way, there's also, you can call it AAR-CRE. So the website's very comprehensive and be able to handle everything online, including payments, can be handled online as well. And so we're prepared to do it. We're ready to do it. We're trained to do it. We have the expertise to do it. We're geared up to do it. We're set up electronically to do it. We've been doing it for 60 years. And candidly, I will finish by saying this, and then I'll leave it to Jim to make his finishing comments. I open all my mediations by saying this to the parties. If I had my sisters in front of me or any loved one in front of me right now, I would tell you to mediate and settle this case. I would tell you to avoid the court or arbitration at all costs. That's what I would tell loved ones that ask for that type of advice. And so before we go to Q&A, I've talked enough. I'm going to hand this back to Jim.
Well, John, thank you very much. That was a comprehensive description and discussion of the new service. We're closing in on about 45 minutes. And John and I have done a lot of talking. I think what we would like to do is hear from those of you online who might have questions. And John and I are available offline afterwards if we don't get to everybody's question right now. I think Tim has been tracking questions, and I will hand off to Tim to start with questions. Tim?
Okay, yeah, so we had a handful come in during the week after we sent out our invitation emails. The first one that we got was, and either one of you can take this, you guys decide, how long do most mediations take?
Well, John, let me jump on that one. Obviously, it depends on the complexity of the matter. Most of the mediations that I've been involved in can be resolved within a day, and very often within a half a day. Assuming everybody comes in with the right frame of mind, that they are all there to reach a settlement, and that people are prepared, 3 to 4 hours is enough time. And a lot of that is on my shoulders and John's shoulders to guide the group and guide the discussion, while also giving everybody a chance to express themselves and share what's on their mind. But a mediation that goes on beyond a full business day would be unusual.
Okay, and we've had, as soon as you guys stopped speaking, we had 3 questions come in from the chat box. All 3 are the same question. What are the costs of mediation, AIR CRE mediation?
I think if I may defer to, well, there it is happening right there in front of us. Stephanie is putting it up. This screen is available on the website under AIR CRE mediation. I think what you will, if anybody were to go to the other ADR services in Los Angeles, they would find this is in line with the pricing model that most other services follow. And not to brag, but for this price, you get subject matter experts. And in many of the cases, many of the other services, you don't. You get an attorney or a retired judge who may or may not know much, if anything, about commercial real estate.
Okay, yeah, so for those attending, you can see it's on our website. If you go to the website, you can get all the pricing information that you need there. Next question is, what real estate matters would not be good for mediation? Is there such a thing?
Pag?
Yeah, well, certainly anything where there's criminal implications, we would stay away from. Eviction matters that are pretty straightforward. I mean, there is mediation for eviction. It happens all the time. But matters that are relatively straightforward, where it's not necessarily a dispute, it's more procedural. Fraud, we would probably stay away from. But I think the world of potential disputes that can be mediated is much larger than the world of disputes that we wouldn't mediate. Those are the things that come to mind.
Okay, next question, and it's a good one. Do you handle non-AIR CRE contracts related mediations?
Definitely.
And in other words, in parentheses, they say, in other words, it's an attorney written, legal document, whether it's a lease or a purchase agreement or whatever.
I would say in virtually every case, the answer to that question is yes. I can always imagine that there might be some issue that surfaces in a specialized lease that we weren't qualified to handle. But that's one of the things you could count on John and me for, is if that's the case, we're going to tell you. We're not going to sign up to be a mediator on an issue that we're not qualified to mediate. And whether a real estate contract was created by the AIR or a big specialized law firm, the issues in commercial real estate they're the same across the board. And the wording may be a little different and the paragraphs may be in different places, but they're not substantively different. So I would say we're able to handle anything. John?
Yeah, in fact, as everyone probably knows, the concepts embodied in the AR-CRE contracts are no different than, as Jim mentioned, they're no different than an Irvine Company lease or a Kilroy lease or an Alan Matkins prepared lease. Those concepts are all shared. The expertise we bring in general to real estate is there, as well as particularly to the AR-CRE contracts.
Okay, and Don Paul asks a good question. And I don't remember, I know we were in the process of this, so you guys are gonna have to help me because you're on the committee as well. Did AIR CRE mediation get added to the contracts as a checkbox? Did we do that yet, or that's in process, right?
That is in process.
But it will, Don, to answer your question, it's not there yet. We had a scheduled committee meeting last month, and one of the participants tested positive for COVID, so we had to cancel it because he was not feeling well. We have it rescheduled for March, and that'll be addressed then. And so to answer your question, it's not there yet, but it will be added. Johnny asked, what do I need to do to apply to become a mediator? Johnny, send me an email at thayes@aircre.com, and I will get in touch with you and we can talk about that. Next question, what if I am having trouble getting the other side to agree? Do you help? What if we are already at post-discovery? Do you take those cases?
I believe this is a question from an acquaintance friend of yours, John, Stephanie Blondell.
Oh,
would you like to pick this one up? Did I get that right, Stephanie?
Yes. Good morning, Stephanie. Stephanie Blondell is an accomplished mediator and also a professor at Pepperdine. Yeah, we'll take mediation at any time if the parties are willing to mediate any time during the process till the gavel slams. We'll still do a mediation. It's completely and entirely up to the parties when they want to come in. In fact, I often said the best time to mediate is when the parties have been beaten up a little bit and paid a few dollars and lost a few nights sleep and have a few scars from the process. Sometimes that's what it takes. Thank you for that question.
And then to answer your other question, what if one side or the other is unwilling to participate in mediation? Mediation is not mandatory, and one side or the other can refuse. However, what has become much more common, for all of the reasons we've already discussed, the backlog, it is now very common that courts will refuse to entertain hearing any case until the parties have attempted to mediate. I've done several mediations in the Central District Federal Court, and it's automatic. Any civil matter filed in the Federal Central District Courts are automatically sent into alternative dispute resolution, and the judge won't pay any attention to the case until that effort has been made. But we would be willing, if the parties are willing to talk to us about mediating, we are willing to talk to them about the benefits and the advantages.
Okay, and Stephanie is not letting you off the hook quite that easy, John. She says the first question was intended to mean, do you all do convening?
By convening, are we talking about joint session versus caucus? I've not heard it called convening, but I have heard joint sessions.
Okay, so Stephanie, I'm going to let you answer that in the chat box. We're going to go on to the next question. No, okay, so she came and said, no, just the pre-mediation phase.
Well, again, if that means speaking with the attorneys, assuming that each side has a lawyer.
Yes. So I think what she's asking is, in the pre-mediation phase, do you guys do anything to actually get the parties to the table?
If necessary, I'm willing to speak to both sides to talk about it. I see my role as a dispute resolver. And if I have to go outside the lines a little bit to move that process forward, I'm willing to do it. It's one of the great things about mediation is we're not bound by rules of procedural, civil rules of procedure. We have a lot of latitude if the parties are willing to go with us.
Okay, if you do not recommend any decisions / settlement advice and are neutral, how do you use your expertise on the legal matters to help settle?
Well, we're not. First of all, any mediator is typically agrees and is prohibited from providing legal advice. Even an accomplished attorney or a judge, when they open their mediation, they don't come and say we're going to give you legal advice, or we're going to. That's what the attorneys are for, and certainly that's not the role of the mediator. However, there is this concept of being evaluative. So in mediation, if I were to go with one of the parties, what we call in caucus, if we separate the parties up and I sit down with a landlord and I say, listen, I got to tell you, I'm a landlord and you're trying to reach back 7 years on CAM charges. And first of all, that's not the standard in the industry. So if I was hired as an expert on this case, I'd testify it's not the standard in the industry. And in fact, if you look at the lease, it says that you're going to charge CAM charges within 90 days at the end of the year. So have you considered the fact that the lease is a little bit unclear, and if anything favors the tenant here on the collection of CAM? Have you considered that the practice in the industry, because I've been a landlord for 35 years, is we really don't do that. And in fact, if I was hired as an expert on this case, I would probably provide the following opinion. So it's not legal advice, it's not direction, but it's providing the benefit in caucus, in private, not sharing, not sharing those things necessarily with the other side, and kind of a reality check, and telling the parties that, and that's where the experience comes in, because an attorney may not have that experience. The attorney knows the law. The law says you will do this. The law says they will do that. But in practice, it's kind of like expert witnessing. And what an expert does is comes in and says, this is how it really works, inclusive of the law or regardless of the law. Have you thought about these things? And then for solutions, have you thought about maybe the solution to this deferred rent thing is renew the lease with the tenant, give them another 5 years, have the tenant personally guarantee the lease so you know you're going to get your payment over 5 years, have the tenant sublease part of the space to help make those payments. Those are the kind of solutions that you don't typically find coming from the law profession. This is not a nick on attorneys that are mediators. The vast majority of mediators are attorneys. They're fantastic. This is a supplement to that. This is an option to that.
Okay, good. I want to be aware of the time. It's 12:02. I'm assuming the both of you are willing to stay. We have two or three more questions. But any of you attendees who want to listen to the answers to a couple more questions, you're more than happy to stay. More than welcome to stay. The question is, and I can take our AIR brokers, Jim, take this one. Are AIR brokers required to mediate if another AIR broker requests mediation, and is it binding?
Yes, that falls under the rules of professional conduct. Every AIR CRE member and that member's firm, when they joined the organization, agreed to mediate broker versus broker commission disputes.
Yeah, I want to clarify that. So it's the AIR rules. Members of AIR are compelled to, required to go to arbitration, but the only disputes that the arbitration hears are relative to commissions. So if it's something outside of commissions, then you could use the regular mediation service, the public mediation service, if you want to, and then the other broker would not be compelled because that's not part of our rules of professional conduct. Once the parties agree to mediation, there's a simple answer. How long before it's scheduled?
That'll depend on who's involved, who's ready. I would say The soonest it could be done is probably within 2 weeks, and that would require that both sides be ready to go, that they have carefully thought through their claim and their response to the claim. So I'm going to take back 2 weeks and say within a month. Most people, especially if they have counsel, are going to need that little bit of extra time to prepare.
Which is a little bit better than 4 years trying to get into a courtroom.
Exactly. We will be far quicker than any court could ever be.
Okay, and then the last question, we have 2 more questions. Do you typically use one mediator, or do parties generally feel more comfortable with 2?
John?
We generally it's one, but Jim and I can co-mediate. That's not unheard of. Typically, one mediator is involved, and typically one mediator is enough. Co-mediation is not unheard of, so it can be done.
Okay, sorry, I said that was the last question. There's actually 2 more questions. Very quickly, can you mediate cases anywhere or only in California?
Anywhere in the United States.
Okay, and then the very last question.
Just to be clear, we're not practicing law. We're mediating. So we don't need to be a member of the bar, and we are not, since Pag and I are not lawyers. But we can advise and assist and mediate anywhere in the United States.
Okay, last question. Do you also offer a neutral analysis evaluation?
If
we do.
Yes, go ahead, Pag.
That is very quickly is one or both of the parties actually, but a party comes to us and says, hey, I've got this dispute, and I'd like to hear from an expert their thoughts. I've heard from my attorney, or I am an attorney, and I get the case law on it, I get the standing law on it, I understand all of that, but I kind of want to know what an expert thinks about this particular dispute. So we do offer those services.
Very good. That is all of the questions we have. John and Jim, I want to thank you for your time. You did an excellent job. Thank you, everybody, for attending. Just a final comment is that the AIR CRE is very excited about rolling out this new service. We've been in the planning stages for the past probably 2 years, making this happen and making sure that we did it right. So if you or your clients are in a situation where you need dispute resolution and you want to make that happen quicker and more efficiently and less expensively than going through court, please give us a call and we'll do whatever we can to help you. Any final comments, Jim or John?
No, I think I, for one, am very excited about this. I think it's a great alternative to the conventional litigation system that we've lived with.
Very good. Thank you, everybody. Thank you for attending.
Thank you.